This is the one judge that we pledged, you gave them the deferred, but you set it for a restitution hearing and also wanted to see what the results of the probation is recommending Saturday.
All right, and who's your client? What's your client's name?
Abelino Lopez.
Could I have the file on Abelino Lopez, please? All right, Ms. Abrams, on this case, is there a top recommendation?
Judge, so for him, his top recommendation is for him to go to safety. The original conditions indicate for him to go to safety if not accepted into felony drug court.
Mhm.
As we are aware, felony drug court is not accepting any new clients at this time. So I did get the safety documents, everything signed this morning.
All right, so you will be going to safety. All right, do you have any questions about anything? Please take advantage of that program and internalize it. And when you're released from safety, make sure you follow through because a lot of people tend to drop off and not go to aftercare, but you'll need to do that, you understand? And if there's anything that you need and you feel as though probation is not addressing it, once you're released, you can come back to the court. You understand? Thank you. And there's a restitution issue?
Yes, Judge, you said it for restitution.
Yes.
We did receive an itemized bill from the university, but without paying into what the bill would be. Our complainant has been using residential treatment as well, so we are unable to communicate with him. We're communicating with the Mexican, which is his sister. She did inform us that she believes that he had on Medicaid, but for some reason the hospital bill is not paid. So we're still trying to gain clarity on that, of whether hospital bills are going to be covered by Medicaid, and then if not, I think we need to get them connected with prime victim compensation so that the bill can be reduced if states need to be asking for the defendant.
All right, so what we can do, Mr. Porter, after he's completed safety, if there's no objection, we can address the restitution issues.
There is an objection because we're set for restitution hearing today. You don't have any witnesses to go forward, then there should be no restitution. But if that's what the court wants to do, I
Yeah.
understand.
All right, and then state, of course, if you have the items before he's released from safety, and if the state and the defense, if you all can reach an agreement, then we can take care of that and have your client by Zoom.
Okay, thank you.
All right, Ms. Ferguson, if you'll put this, we're just going to put it in February because everyone should have some information by that point. So we'll put it in late February for restitution hearing.
Thank
Darren Villarreal.
She's present, counsel. Nothing further.
All right, where are we on discovery?
Judge, we should have discovery. There's a misdemeanor out of the same incident. I've gotten discovery through that. I know that I've gotten an offer from the state. We've discussed the case. I'm sorry, I have not gotten an offer because we've discussed the case. The state needs to look at the video before they can make an offer. So we're asking for some time to get that done.
All right, Ms. Ferguson, if you'll set this in the second week of December and state at that time you need to be prepared to tender an offer.
Yes, right.
Thank you, Your Honor.
Yes. All right, once you sign the reset form, you're excused.
Fine.
Eric Simmons. Eric Simmons going once. Eric Simmons.
Eric, come on up.
Hello. I'm doing great. How are you doing? All right, today is plea deadline date. Have you all reached an agreement or is this going to be a jury trial?
So here's the deal, Judge. There were some CPS records that I just received the disc today. There was also an issue with some body cam that they say has been uploaded to e-discovery. I didn't get them when I downloaded everything, but they say they're uploaded, so I still. They have made an offer. We're not willing to accept that right now. But if we could just reset for the big bargain deadline, see what happens with that new discovery.
All right, this will be your final plea deadline date. Ms. Ferguson, set this for the last week in December, please, that we're here. All right, that will be your final plea deadline date. Counsel, you'll need to provide them with a thumb drive, maybe.
Oh, no, I've got the, oh, for the body cam.
Yes.
Yes, Judge.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you, Judge.
Matthew Maher. All right, today is plea deadline date.
Yes, Judge, we have a plea date on a misdemeanor that will dispose of this case of January 7th in order for him to finish.
Okay, why was that like January 7th? Because we were here in October, and then there was a plea deadline date for November 3rd. Then there was the misdemeanor case that you all were supposed to work out. And then today is the day for,
I understand, Judge. We've worked out the misdemeanor case. There's some classes that are as a part of that deal that I was unaware of when I talked to you.
Mhm.
I understand that we need to set it for trial. And I'm just asking, my request would be we set it on the day that we're supposed to plea, because I anticipate it being resolved, but we're at the
When is
pleasure of the
that?
court, January 7th.
all right, Norma, recall this for January 8th. There, and that's gonna be, well, just one moment, not January 8th, Ms. Ferguson. Do it for January 12th, and that's your jury trial date and plea deadline date. If things are taken care of before then come back.
We'll come back and hopefully we'll be here on the 7th to let you know.
All right, thank you.
May we be excused once we get that?
Yes,
Thank you.
you're welcome. All right, Jose Escalante. Have you conferred with the state?
I have, Judge. It's really just a clarification of a previous order you already entered, Judge.
Good afternoon, Your Honor.
Good afternoon. So he's asking for contact with his minor children and the motion. Is there going to be any objection?
Did you previously granted that? The problem is in the order you gave him permission to have supervised contact with his children, which we're not objecting to that.
Mhm.
But you also ordered that he cannot have any overnight stays with children. So GPS is interpreting that to mean even if he's supervised, the kids can't sleep in the house with him. So him and the family are having to sleep in separate quarters.
All right. It's going to have to be supervised. All right. Is there anything else?
That's all we have on for the Judge.
All right. Thank you. All right. You too. And if you'll bring up your other client. All right. And you're David Solomon. Join us. All right. There's a motion to modify bond conditions. Is there an agreement or no?
This is a case we just finished, I believe, last week. Down to the date view on the 14th.
Mhm.
Down to Naka's court where we did one. And Judge Nakata ordered partial GPS, a bond of 50,000, no contact order with complainant, and no possession of firearms.
Okay. All right. Court is calling 2023 CR 2677 State versus David Duenas. Could I have parties announced?
Raymond Martinez, Mr. Duenas.
And are you Mr. Duenas? All right. Defense has filed a motion to modify bond restrictions off record. State is stated they're opposed to tracking only. All right. And you're stating that Judge Nahara did order partial GPS for employment or no?
Yes, for employment.
So counsel, what is the issue with partial for employment?
Judge, the problem is that Mr. Duenas sells cars, and as you know, car salesmen are constantly on the go, test driving, moving cars, et cetera. And so with partial, he's allowed to go to the dealership, but he can't leave and actually do his job.
Now, this is fascinating. The defense argues partial GPS is too restrictive for a car salesman. Yes, a car salesman. Even the courtroom gets practical here. Jobs don't pause for legal constraints. But the state pushes back. The underlying violent charge makes travel risky. This is the delicate balance of freedom versus public safety. Think of it as law versus logistics. Who wins here depends on both precedent and real-world reasoning.
So, and in the past, when he's been on GPS, he's been allowed to do tracking for the same reason. He's been in the car business for a long time. The second issue, Judge, is he needs to travel outside of Fair County, sometimes to deliver cars to other dealerships in other cities and or bring them back. And so we're asking for a travel permit within the state of Texas.
And the state would object based on the charge, the underlying charge, Your Honor, this defendant did shoot at somebody. I believe, and you can correct me if I'm wrong, but it was his ex-girlfriend's new boyfriend that he was shot at. And then on this case, he picked up in his case for choking, Your Honor. And so we believe that this defendant is closer to and we believe that on that basis.
All right, any further argument, counsel?
Judge, I mean, the underlying MTR, Judge, that was a trial case before a jury, and that's already been resolved. On the MTR, we're set for contested in December. He's gonna have a whole month out of work if he doesn't get these modifications.
Okay, all right. The motion to alter the main conditions is denied. Is there anything else? All right, thank you. All right, so has the sealed family violence case been taken care of?
It has not, Judge, Ms. Jones was looking, yeah.
Ashley Jones for the state. Your Honor, I did look into the case. It has not been assigned an intake prosecutor yet. It was just filed with our office, I believe, in September of 2025. And so it's going through the process of getting a file jacket and getting uploaded to our system. I do not have enough information on that case to concur with defense on that.
All right, so when are you going to have information?
Your Honor, I put in a request for several, for police reports so that I could get more information. And then I put in an email to our file officers so I can see when it is with permission.
All right, counsel, will you be here the second week of December?
I will, Judge.
All right, Ms. Ferguson, set this for the second week of December, and that will be for discovery. And if you don't have the information, you all will need to present on the record the reasons why that information is not available for defense, who has it, and they'll need to come down to explain why the defense doesn't have it. What date? All right, we'll be back on December 11th.
Thank you.
Thank
Judge.
you. Israel Gonzalez. Why were you late for court?
I went to the one downstairs at S. When I grew up.
All right, so here's the thing. What court did you have downstairs? Which court?
Forgot that I got a new judge.
Okay.
I went to the wrong one.
All right, so now you know where it is. You should have already known where it was because you've been here before. So do not make that mistake again, all right? All right. State, were you able to tender an offer in this case? It's Israel Gonzalez. And I believe this is going to be family violence as well.
He just got indicted on another case, Your Honor, which has just been handed the indictment.
Okay. And is that through family violence?
Yes.
Family
Well,
violence.
Yes.
You have Israel Gonzalez. Do you, with regards to that case, are there CPS records?
You'll give me just one moment.
Sure. I'm just waiting for information.
Okay, Judge. I have three clients. All right. Then I have 8 in Atascosa waiting for me.
Gonzalez's case, I did not personally confer with defense counsel, but I can review it and make an offer if that's.
Well, he has another case.
Yes.
That's another second-degree felony with family violence. Yes. So this is what we're going to do. Norma, recall this for the last week in December. State at that time you need to be prepared to make a global offer.
December what?
And state on that case, that family violence, if there's CPS records, you need to obtain those. If there are phone records, mental health records, school records, you need to obtain those.
Yes, Your Honor, I apologize. It's pulling up. I do believe it's not.
And Your Honor,
It's not
I
united
also
yet,
have,
so it's-
Yes.
also have the issue, my client's been on GPS monitor since April. I have the alleged, the second crime, offense that he's been indicted for. And I filed the motion to remove the GPS, but it was in the wrong court because it was not indicted yet, so I would ask court to take up that, but I guess I would have to file the hearing, the motion so we can set the hearing so you can hear it.
Yeah, and what I can tell you, if he has all of these cases that are on different dates,
Multiple cases stacked up like a Jenga tower. One wrong move and the whole strategy collapses. The judge carefully explains why GPS isn't optional, it's preventative. It's a real reminder that courts aren't just reactive, they're proactively weighing risk, even when no one's been convicted yet. Audience question, would you accept GPS under these circumstances if you were the defendant?
there needs to be a good reason for GPS to be removed because let me just tell you, I don't take any of these offenses as you're guilty beyond a reasonable doubt because I have not had anything presented to me. But what I can tell you, if you have a felony bond and you are alleged to have committed a new offense, then maybe GPS is where you need to be. You understand? All right. Do you have any questions about anything?
Oh, yeah.
All right. Once you sign the reset form, you are excused. All right. Thank you.
You're fine right there.
Enrique Jacoba.
Jacobo?
Huckaba. Okaba.
Right, that's all.
Good morning.
Good morning.
I'm gonna have to work on that one. All right. Today is plea deadline date. Have you all reached an agreement?
Not yet, Judge. We've actually filed a motion to suppress on the matter. I think it would be a dispositive matter or motion, excuse me. Pending that, I think there could be a plea after that, but
All right. Is the motion dispositive?
I believe so, Judge. Yes.
All right. All right, state.
Yes.
They're saying that they want a motion to suppress and it will be dispositive. All right. Are you able to do this before the new year? You mean December? All right, Ms. Ferguson, if you can put this for a motion to suppress second week in December, please. State, are you all okay with having this on the 12th? That's a Friday. Would that be easier than the 11th? All right, Norma, put it on December 12th, please. All right, thank you. And I did that because I think it will be easier because we have an interpreter and there are a lot of moving parts.
Sure.
All right, thank you.
Thank you, Your Honor.
And if you could sign an acknowledgement of discovery before you leave.
Absolutely.
Nifa,
Yes, ma'am.
is Julius Martinez here?
Yes.
All right.
It's here now.
All right, thank you. Okay, you can continue conferring. I just wanted to know if he was here.
We already conferred, Your Honor. On Mr. Martinez, I just want a December 2nd, plea.
It's on page 15, Judge.
Page-
First one.
And why can't that be done today?
Page 6, I'm sorry.
Well, unless I can come back tomorrow, Your Honor, because I have 8 people waiting for me in Atascosa, so I gotta go from here to Atascosa, and we can come back tomorrow.
All right, complete the plea paperwork and you can appear by Zoom because today is his plea deadline date and he was late for court.
Okay, yes,
Thank
Judge.
you. So that's gonna be 1:30. Zoom,
Okay.
yes. Miguel Contreras. Hi, how's it going?
Good, how are you?
All right, are you all ready to proceed on the MTR?
We are, Your Honor.
Court is calling 2024 CR 012263, State versus Miguel Contreras. Can I have parties announced for the record for the state?
Okay, we're into the consequence zone now. Deferred adjudication violations can trigger serious penalties, up to state jail time and hefty fines. Notice the court carefully lays out what pleading true means. This is where legal clarity matters. Defendants must understand the consequences of every single word. It's tense, and you can feel it even through the transcript. Would you risk going true without understanding the potential fallout?
And Lauren left in for Mr. Contreras.
All right, and are you Miguel Contreras? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Miguel Contreras Jr. who was placed on deferred adjudication in 2024 CR 012263 for the offense of evading arrest detention with a previous conviction on January 23rd, 2025 for a period of 4 years? Is that you? All right, state.
Petition number 4, and their county corrections defendant Miguel Contreras Jr. did then and there fail to report supervision officer as directed for the months of July and September 2025 in violation of condition number 4.
How do you plead to that? True or not true? State.
Please abandon their maintenance, Your Honor.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there a proposed agreement?
There is,
Yes, Judge, it is for the court to deny the state's motion and alternative amendment conditions for mental health.
he's, not to interrupt, but he's already completed his mental health, so the agreement was for him to do the outpatient dual diagnosis intensive program, is that correct?
Judge, the recommendation and agreement is for him to be placed on the mental health initiative caseload and for him to complete the dual diagnosis outpatient program.
Thank you.
All right, thank
That's
you.
what I tried.
All right, do you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record.
I'm Miguel Contreras.
All right. Mr. DeLeon, do you need a cough drop? Okay. All right. So what has been going on with you?
I was staying at my brother's, but it didn't work out there. Well, them getting like a power attorney over me or whatever for helping me with this.
All right. So this is, I'm going to give you a choice. I don't know if you'll be successful in this probation or not. My hands are sort of tied with the different programs that I can have available to you because there's a lack of funding. There's a lack of placement. Now, I can follow the agreement that has been reached, or I will sentence you to 8 months in the state jail facility. So do you want me to follow the agreement?
Yes, please.
Okay. So the court will deny the motion. Alternate amend conditions to include MHI plus outpatient treatment with dual diagnosis. And Ms. Abrams, because there may be issues with him, can you make sure that they do the field visits? And so there'll be field visits 1 time per month until further notice. And we're doing the field visits to make sure that you stay in compliance, okay? I want you to be successful at this.
And I don't know if the court could order, but I did tell him to ask for employment resource or help with that, as well as housing assistance.
All right, so employment resources and any housing resources. And there is a program, I want to say it's called Build Back Brighter, something of that nature. They can help with housing as well. They're a nonprofit, but they may be able to help you.
I'll Google it and maybe write the information down.
All right, thank you.
Okay,
Thank
thank you,
you.
Judge. May I be excused?
Yes.